This is Gregory Allen with the AI Policy Podcast. On today's show, we're talking with Dean Ball of the Mercatus Center about state and local regulation in AI, which in his words is where the action is. My guest today is Dean Ball, who is a research fellow in the Artificial Intelligence and Progress Project at George Mason University's Mercatus Center. In addition to his role at George Mason, Dean Ball is also the author of the Substack Hyperdimensional, where a lot of his work goes out these days. And before this, he was a senior program manager in the Hoover Institution's State and Local Governance Initiative, which is not the only thing on his resume focused on state and local governance initiatives. So at the intersection of AI and state and local government policy, we're very lucky to have you here, Dean. Thanks so much for coming on the show.
Thanks so much for having me.
So before we get into the weeds of all these hundreds of bills that are out there right now, I kind of want to understand a little bit more about you. So you've been doing state and local policy analysis work for a while. How did you get into that work, and then how did you get into AI?
Well, it really all started for me in college. I read a book called Triumph of the City by Ed Glazer. I went to college in upstate New York, and it kind of, reading that book, it occurred to me that not only are cities these interesting economic units, but they're also governance units, and they have like local governments. And in fact, New York City has, a government that dwarfs the size of most governments or national governments around the world. And so that seemed really interesting. And like there were a lot of practical problems to be solved. So I went and interned for a think tank called the Manhattan Institute, where Glazer was affiliated, and sort of like followed in his footsteps, I suppose. And then ended up getting a full-time job there, did state and local policy at Manhattan Institute for about 5 years, took a brief detour, about a 4-year detour, doing some other things that were related mostly to like policy and economic education of young people. And then really realized I loved state and local policy. So went back to it at Hoover from about 2022 to 2024, and then joined Mercatus to do the AI policy writing. But kind of in parallel with all that, I've always been very interested in technology. Most of my state and local work was things like housing, transportation, public safety, and economic policy. Not really a lot of tech policy. But since I was a kid, I learned to program when I was like 10 or 11 years old. I've always been very interested in that. And so this seemed like a good intersection, though I will say, when I joined Mercatus, I was not really expecting to be focusing on state and local policy all the time. It's just so happens that is kind of where all the interesting domestic policy on AI is being made right now.
Yeah, so at the same time that the federal government, especially in Congress, is mostly gridlocked, it's really hard to pass any kind of laws, the states are taking up that mantle, exercising their governance authorities, and which is why we wanted to have you on the show. So at least according to the tracker put out by Multistate, there are now 833 bills related to AI that have been introduced so far in 2025, and we're only in March. That's an average of 16 per state. So way more than what happened in 2024. What do you think is really the story of how we got here with this explosion in legislative initiatives? Like, what has prompted this influx of state-level AI legislation?
I think it's a few different things, but if I were to summarize it in one sort of point of view that you hear on the left and the right very frequently, it's we don't want to repeat what happened with social media. Now, you can debate whether what happened with social media is really something that public policy could have ever fixed. Like, could you have ever foreseen what would have happened in like 2007 or something and passed a law to fix whatever it is you think went wrong with social media? I'm skeptical of that, but that is the general sentiment, that we need to get ahead of this because we didn't get ahead of other big technologies, and now we feel as though, we being the policymakers, feel as though those technologies are beyond our control.
And that's so interesting because, Meta, obviously one of the largest social media platforms on earth, has been running advertisements saying that they support comprehensive legislation on social media for, 5 years now, and yet it still hasn't happened. So how has it happened, that the number one giant behind this, quote unquote, supports comprehensive legislation, but it keeps not happening. This gridlock phenomenon is pretty remarkable and pretty stubborn. And so, as you said, policymakers see AI and they're like, okay, maybe social media is beyond us to fix, but maybe we can prevent AI from becoming equivalently broken, or at least that's the ambition. And I think it's interesting that there are folks on both the left and the right who use this exact same language of, we got social media wrong, let's not get it wrong when it comes to AI, which is interesting because people don't make that argument vis-a-vis the internet writ large, right? They often say that not regulating the internet in the early days was a win, but not regulating social media in the early days was a loss. It's not clear to me that this historiography is like intellectually consistent in any kind of way, but it is sort of where we find ourselves here. So, all right, there's 833 bills, 2025 alone. Colorado has actually passed something that has become law. A lot of other states have either passed something that is awaiting a governor's signature or are, still haven't passed anything. Can you bring some order to this madness? Like, how do we understand this universe of 833 bills?
Yeah, so I would taxonomize them in a few different categories. First category is fairly anodyne, sort of like the legislature is going to create a committee to study the effect of AI on blah, right?
Classic government move.
Yeah. And that's like several hundred bills right there. So you can take those kind of off the proverbial table. Number two would be deepfakes. That's a big one. And there's a wide variety of different deepfake bills, but for the most part, this is not preemptive legislation. For the most part, what this is doing is creating a post hoc sort of either civil or criminal offense.
So this is sort of like, we've always sort of thought that revenge pornography was bad. We think that the AI deepfake enabled equivalent of revenge pornography is bad. Oh, it turns out there's not a law against that? Well, we're going to make a law against that, or something to that effect?
That's right. I mean, sometimes it's actually redundant. And then in other states, I did a pretty thorough survey of the statutory and common law in all 50 states to look at this issue. And it turns out that there are actually some states where knowingly distributing a malicious deepfake of someone is not in and of itself an offense. And so
they wanted to make it one.
They wanted to make it one. In other cases, it's more of a symbolic move. So there's that. And that's a big chunk right there. So you're already taking like quite a lot off the table. And
sorry, just on the deepfake thing, we talked about the malicious deepfakes in terms of pornography or child sex abuse material. There's been a lot of political momentum for that. Even when I talk about what might pass in Congress, I usually say deepfakes is the one where you can imagine something resembling a bipartisan coalition getting there. There's also the political type of deepfake, right? You can imagine some major political figure you create a deepfake of them saying something incredibly scandalous that they never actually said. Do you think there's any momentum there in addition to the other categories that we were talking about, or is that sort of its own animal?
There have been a bunch of political deepfake laws that have moved last year and that will move this year, I suspect. Some of those are going to run into constitutional problems. It's very hard to craft one of these laws in such a way
that isn't a First Amendment issue?
Yeah. I mean, and California passed a very ambitious version of this that was enjoined by a court, by the Ninth Circuit, within like a week of passing. And so we'll see that too.
Yep. Okay. So we've got create a committee, big bucket. We've got deepfakes, big bucket. Keep going.
Yeah. And then we get into the more substantive buckets. And I would kind of divide that between two categories. The first, you have kind of near-term, more, you might say mundane risks from AI. So the big thing here is algorithmic discrimination. And I'll talk about those in more depth, I think. But there's about 15 to 20 of those bills. And these are very, very large, complicated bills affecting businesses throughout the economy, affecting AI development. So this is probably, in terms of, I think, the impact of the bills, these are the most impactful bills being considered. And then there are bills aimed at...
Wait, can we pause there for just 1 second?
Sure.
We were talking about how there's been a lot of inaction at the federal government level. But in the case of algorithmic discrimination, it's true in Congress, but it's not precisely true in the federal government that there's been a lot of inaction here. So if you think about organizations like the Equal Employment Opportunity Commission, which has been around since literally the Civil Rights Act, which created it, they basically say you're not allowed to hire, fire, promote, or give a bonus to somebody on the basis of race, right? You need a reason that is not race for why you are taking all of those actions. And what the EEOC has said, which I think is true and good, is that your use of AI is not a get out of jail free card in abiding by that. So you can't, just go to a judge and say, hey, I'm sorry, it's the AI that's racist, not me. If I had known it was racist, I never would have used it. It's like, well, look, you fired somebody on the basis of race. You hired somebody on the basis of race. You gave a promotion to somebody on the basis of race. It doesn't matter that AI was the reason behind that. The existing law already applies. And the same, I think, applies in the case of housing discrimination or financial loan offering discrimination. So I think to the federal government's credit, a lot of these agencies, a lot of these commissions have sort of noticed that their existing laws, apply in an AI-enabled world. And so it's not that there's been inaction, it's just that the action that was most urgently needed was clarifying guidance to issue, not some new rulemaking type of activity. And so I just want to point out that it's interesting that in these states, they're sort of saying, whatever's going on in the government, whatever's going on in the agencies, it's not enough. We still want dedicated legislation that is specifically focused on algorithmic discrimination, which I think is an interesting choice.
Yeah.
Right? It signals something that they want that.
What they want specifically is preemptive regulations. So the difference between what you've also seen, by the way, lots of state AGs take algorithmic discrimination related actions against AI companies. Using
their existing legal authorities without new laws.
Yes. Consumer protection, civil rights. I mean, every state really has one of these. So there's a robust set of law in America about this. That's one of the points I've made, kind of pushing back on these laws. But what these laws are really more about is preemptive action, as opposed to enforcing the laws after an alleged discriminatory.
So can you just unpack what you mean by preemptive action?
Yeah. So preemptive action in this context would mean requiring both developers and quote unquote deployers of AI systems, which is to say commercial users in regulated industries, before they use AI on a per use case basis. If it's going to be something that, if their use of AI is going to be consequential, as these laws define them, the company has to do a variety of compliance steps, including writing algorithmic impact assessments, creating risk management plans. And so these are kind of lengthy compliance steps that you have to go through before you are allowed to use the AI system in any practical way.
So to use like what I think is a straw man example, but like, are you regulating a power plant in a post hoc environment, which is, hey, you spilled a bunch of chemicals into the river, and now you're going to have a big fine? Versus, are you regulating the power plant on the basis of, hey, you failed to put in place procedures that we believe prevent such spills? That's the preemptive regulation, and that therefore you're being punished for failing to put in place those kinds of safeguards.
Correct.
So what you're saying is that in the case of algorithmic discrimination for these state and local bills, what they're interested in is this kind of preemptive phenomenon.
Yeah, that's right. That's right.
Great. Keep going.
So the next category and the last one is what I would call frontier AI regulation. This is a small category. It always has been. Last year, the most prominent AI policy debate in America, I would argue, was a bill of this kind from a state, the state of California, SB 1047. And we can go into more detail on what that bill was, but I would say there are a few such bills this year. We've got some sort of whistleblower protections, for example, moving in a few different states specifically for employees of frontier AI companies. And these are really bills that are intended to regulate in various ways the most severe anticipated risks from AI. So we're talking about, wide-scale cyber attacks, the ability to create bioweapons with AI systems that are not even on the market today.
Yeah, this is intended at like catastrophic risk or existential risk. I think it's fair to say. So
system autonomy, things of that kind.
Yeah. So this is only for those largest models that are either aiming at explicitly or unexplicitly human level AI and beyond. So in the case of the Biden administration executive order, they classified this based on how much computing power went into it, 10 to the 26 flops. Not all the laws are going to do it that same kind of a way, but we're really narrowly talking about these frontier systems, not just every image classifier, not just every voice recognizer, sort of vanilla machine learning.
That's right.
Great. Okay, so This is an awful lot, and we could go in a lot of different directions here. But I want to start, now that we've got our buckets, I want to start with a piece that you wrote recently in February 2025 titled "The EU AI Act is Coming to America." So what did you mean by this, and what would you say is the influence of the EU AI Act on state AI bills more generally?
So the algorithmic discrimination bills that I mentioned earlier are part of a common framework that was developed under the auspices of a sort of a multi-state group of legislators throughout the country, Republican and Democrat. And those bills are quite influenced by the deployer side provisions of the AI Act. So the AI Act requires deployers in regulated industries, banking, insurance, healthcare, et cetera, to conduct fundamental rights impact assessments before they deploy AI. In the United States, we have laws that require people in those same industries to do algorithmic impact assessments before they can deploy AI. So a lot of the mechanisms, terminology of these bills are actually not just similar, but sometimes word for word the same, taken from the AI Act.
And sometimes that's because like they're drawing upon language from the OECD, that the EU was also drawing from.
Sometimes, yeah.
Sometimes that's because they're drawing from stuff like the NIST AI Risk Management Framework or ISO, what's the number there? 42001, standards that are meant to be international, that a lot of legislative things do it. But you're pointing out like the basic mechanisms and mindset. You're seeing a lot of echoes between these state bills and the EU AI Act.
Yeah. I mean, I would actually really even say the algorithmic discrimination concept more broadly started in the era of narrow AI systems. So we're talking about facial recognition.
Pre-ChatGPT revolution.
Pre-general purpose ChatGPT style models, right? A bank creates a specialized statistical model to predict the likelihood that a loan applicant is going to pay back their loan. And it's entirely reasonable in those contexts to ask the question, what kind of data are you using to train that statistical model? Because if it's the bank's historical data, there have obviously been periods in American history where African Americans and women and other civil rights protected groups were not able to access financial services as well as other people could.
Right. If your AI is basically saying, "Hey, we did everything right in the 1970s," so just create a model that basically exemplifies a bank manager in the 1970s. Well, you're going to run into a lot of trouble there.
If it's using historical data as pure ground truth, then I think there are legitimate questions to be asked. But those laws are really tailored for that kind of a system. And the AI Act, the EU AI Act itself, was tailored for those kinds of systems because it started to come to fruition in the early 2020s, in like 2020, 2021, before ChatGPT. And then ChatGPT came out, and it was this kind of enormous inconvenience for everyone.
They were like, we were so close.
Yeah. And in the EU, the way that they handled that was they created this new GPAI, general purpose AI distinction, and there's this code of practice, which is for sort of frontier AI that's being drafted right now in the EU. I bet you will see that influence American states too. But really, the states are taking this kind of pre-existing thing from the EU, which I think was outdated when the EU passed it, and is even more outdated now. And they're trying to apply it to general purpose models.
And it's not like a one-to-one. I mean, if you look at, for example, the Virginia AI bill, which I think is one of the ones that you pointed out, has some echoes of the EU AI Act. The fines are very different, for example. I think Virginia is like $10,000 fine per violation, which is like what Mark Zuckerberg uses as Kleenex, right, would be $10,000, compared to the EU AI Act, which is 6% of global turnover, as the potential maximum fine for a violation. So that could be like tens of billions of dollars, literally. So it's interesting that there's like these echoes in mechanisms, there's some echoes in mindset, as you're pointing out, but there's also like these crazy differences in what implementation and enforcement might look like.
That's true, although what I would say there is that the big tech companies are actually going to have a pretty easy time complying with these algorithmic discrimination laws because the requirements on them are actually not so heavy. They really need to disclose some stuff about training data, some stuff about training practices. They need to have a risk management plan, et cetera. It's mostly stuff they already have in place.
Yep.
The people that will really bear the burden of this will be the commercial users, which are going to be, in Virginia, in fact, literally I would be a deployer of a high-risk system in some contexts. Like if I lived in Virginia and I tried to hire a nanny and I used ChatGPT to filter resumes, that is a deployment of a high-risk AI system for the purposes of the Virginia algorithmic discrimination law. And so technically I, as an individual, would have to write the algorithmic impact. I mean, I don't think anyone's ever going to enforce
Aren't
it at
there
that
like
level.
exemptions for size of business, though?
In some states, but not in Virginia.
Oh, interesting. So a household employer with one employee might theoretically be subject to this.
Yeah, they're not thinking about that, though. You know, I mean, this is the thing, is they're in a completely different mindset from the way that these systems are actually being used on the ground.
Yeah, that's interesting. Now, you said that the big model developers, like an OpenAI, are probably going to be more or less unaffected by a lot of these laws. But at the same time, we saw OpenAI's response to the White House Office of Science and Technology Policies, RFI, and the AI Action Plan. OpenAI is asking for, quote, relief, end quote, from state and local AI regulation in exchange for a, quote, voluntary partnership between the federal government and the private sector to protect and strengthen American national security, end quote. So what do you make of this interesting phenomenon whereby, at least in your own description just a moment ago, the big model deployers are not the ones who are principally affected. However, they are asking the federal government, to get involved and try and head off some of this work.
Well, I'd say a couple of things. First of all, these algorithmic discrimination laws do create the possibility of negligence liability on developers for instances of discrimination. And I think that...
Can you just walk us through a scenario for how that might happen?
Well, I mean, I guess one good example would be if I'm trying to filter resumes. Employment is covered in all these laws. If I'm trying to filter resumes and I say, show me people with a advanced degree in machine learning, and that filters out, it only shows me Asian men after doing that, then in some world that could be discriminatory.
But you said negligence, though. What's the negligence mechanism?
The mechanism there, I mean, it's that they have to exercise reasonable care to avoid algorithmic discrimination. So I think that, trial lawyers can be quite creative, and I think we've seen that throughout the last 50 years of American history. So it would not shock me in the slightest to see, especially because, the frontier AI developers have the biggest pockets. So if your option is suing some random bank in your state versus suing OpenAI or Microsoft or Meta or whatever, you'd probably, if you could find a way to sue the bigger guy, you probably would.
Oh, interesting. And I think I'm just thinking out loud here, but another point is that they, as big frontier AI model developers or big cloud hyperscalers, they want their customers to succeed, right? And so if their customers are these deployers, whether that's a bank, whether that's a local business, et cetera, if those local businesses are scared of adopting AI, then that's sort of bad for the providers and in terms of being there.
That's right. It also diminishes their customer base, I would say. And finally, I think, they're looking at the writing on the wall and seeing what could be coming next. Because if the states do this year, then next year there's going to be something else, and there's going to be something else. It's not going to end with just this.
Yeah, I mean, there's kind of two ways that legislation can go. You can have something happen and, okay, good, glad that we fixed that, that's done. Or you can have something happen and that's now a precedent that things can happen in this world, and suddenly momentum starts snowballing.
Yes, and I think specifically in the case of the algorithmic discrimination laws, these are laws that are going to inspire lots of more laws, lots of additional laws, and lots of additional guidance. In the EU, they view this as a feature. They're like, every country can have its own AI office that promulgates guidance and standards around how to implement the AI Act. We're seeing this. The one state that's passed an algorithmic discrimination law is Colorado. It was called SB 205, and it passed in May of last year. That law was at the governor's request. The implementation date of that law was delayed until 2026, February of 2026, to give them this legislative session to work out the kinks, because he viewed it as a very complex. He was, Governor Paulus had very significant reservations, but signed the bill anyway. They created a 1-year task force of the legislature to bring in stakeholders and try to figure out how to implement this law. And after a year of meeting, the task force released its final recommendations a couple months ago, and basically said we have made no progress on how to implement this, because they're very, very, very difficult laws to implement when you actually think practically and you actually bring in the perspective of people that are building technology, that are using technology. There are hospitals that have said we would have to cease our use of all kinds of diagnostic tools if we use this. We're trying to create new AI diagnostic tools for people with Parkinson's or whatever, but we have not satisfied the very, very, very rigorous requirements of this law on algorithmic discrimination. And so we would just have to cease use or spend hundreds of thousands of dollars on technical and compliance work.
Amazing. So I want to rewind a bit to something you said a bit ago about a multi-state grouped that was influenced by deployers that is sort of responsible for driving some of this. So we're seeing a lot of bills, pop up in various states. As I mentioned, there's more than 800 out there right now, just in 2025 alone. To what extent are these copycats of each other? To what extent is there some external actor that is just promoting the same draft bill in multiple worlds? And to what extent is this a partisan or bipartisan phenomenon?
Yeah, you see this very frequently in the states. The states are very mimetic. If they know somebody else if they know a legislator in another state who they perceive as having thought a lot about this issue is using certain text, they'll just take the text and copy it. To the point sometimes that there are drafting errors specific to the statutes of another state.
Referencing Texas law, blah, 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 but in Colorado.
That will happen occasionally. There are a few groups here. There's the one most prominently is a group convened by a nonprofit called the Future of Privacy Forum, which also has done a lot of work on privacy laws in the states, which have tended to mimic each other in various ways as well. That group convened a multi-state commission of different legislators, and pretty much every legislator on the steering committee of that group has introduced one of these bills, and they're all remarkably similar. This is, Virginia, Texas, but also places like Arkansas and Georgia and, Massachusetts, Connecticut, all over the place.
So this is
and same with Colorado.
States controlled by, different parties.
Yes. Yeah. So I would say it has been bipartisan so far. And, to a certain extent, it's, we need to do something, and this is something, and this is, it's like a 50-page bill. It seems very well fleshed out. And so I think that there's an element of, of some degree of coordination that's going on here, which is, again, quite common.
It's funny. Just thinking out loud, you said a 50-page bill. I think the Virginia bill, when we counted it, was more than 6,000 words, which sounds like a lot until you meet the EU AI Act, which is 90,000 words, which is not quite dictionary length, but boy, it's a long bill.
Yeah, and I love the EU just released their definition of an AI system, and it was 10 pages long.
It's complicated. What is the meaning of life, basically, is what they're getting to.
Yeah.
Okay, so you said it's bipartisan. I think this would probably be surprising to a lot of folks because AI was a mostly bipartisan issue in Congress from 2016 until certainly by 2024. I think it started to become a more partisan issue. Is that sort of the same situation in the States? Do you see it becoming more partisan, or what do you think is going to happen?
I find it remarkable that it's been this nonpartisan so far. So just as an example, Texas, which kind of does now fancy itself as a leader in Republican tech regulation. They had a very aggressive social media bill a couple of years ago that went to the Supreme Court. It was no viewpoint discrimination in social media content moderation. So they do introduce quite partisanly coded tech policy bills. Texas's AI bill was the same as Connecticut's and Massachusetts, basically. In fact, more aggressive than those from a regulatory stance, but not in a partisan coded way. More it's Texas doing an algorithmic discrimination bill based on disparate impact, which Republicans hate. And the very disparate impact-based definition of algorithmic discrimination is the first thing in these bills, first definition in these bills. And it was right there in the Texas bill. And that was quite remarkable to me.
Yeah, and I guess at this stage, though, we're still talking about draft bills because Colorado, to my understanding, is the only state that's actually passed a big one.
That's right.
But it's even the fact that the drafting is so bipartisan is kind of in and of itself interesting.
Yeah, right. I mean, and this bill, so in Texas in particular, this bill actually just got completely rewritten. And got a new bill number, but it was called the Texas Responsible AI Governance Act, TREGA. And the Texas legislature's been in session for a month and a half now, and it lived for that whole time. But I do think, frankly, Texas in particular, a lot of people sort of with a more national lens have been scratching their heads about that, thinking to themselves, why is Texas doing a disparate impact bill? And all of this when this is Trump is releasing an executive order once a day that goes after some aspect of disparate impact. So, yeah.
Yeah, I mean, do you think there's any shot of that bill, either in its original form or its revised form, of passing? Because, as you said, as somebody whose focus tends to be more national and international, I would not have predicted, Texas to be the one.
Yeah. So, I mean, I think that there was a real chance of it passing even in its original form. But the legislator has gotten such pushback that he has completely rewritten that bill. And it is now much more sort of coded along traditional partisan lines, which is to say, the bill focuses on, it prohibits governments from, Texas government agencies from setting up social scoring systems. There's a real fear of this in a lot of, I think all over the place, but especially conservative circles on, a CCP style social scoring system.
Yeah, where you can't get a loan if the Communist Party is mad at something you said on social media, et cetera, et cetera. Not super plausible that the Texas government would set that up if we didn't block it with legislation, but okay.
I would be surprised. I also think the way that it's written will probably harm the ability of a lot of Texas state agencies to use their data to do much of anything interesting from an analytical perspective. But that's a secondary point. There's also something they're trying to do this social media content moderation thing again, but they're doing it from an AI perspective rather than from a social media perspective. So they're saying it's illegal to create an AI system or use an AI system in a way that could be used for viewpoint discrimination on online platforms.
Yeah, this gets back to the traditional Republican fear of anything coded as safety is actually a secret plan for censorship, which has been a big fear of theirs for years now.
Yeah, and I think that they're going to create. I mean, I think NetChoice, a common interest group that files lawsuits against these kinds of bills. I think NetChoice will file suit within hours after if this bill becomes law, and I think if they do, they're probably going to win. Because in fact, I think it's actually counterproductive. Because I don't really think that sort of algorithms, AI algorithms of any kind, are going to be considered free speech in most contexts. But for whatever reason, state legislators are obsessed with one of the few use cases where it is kind of unambiguously a form of speech, the use of AI in content moderation. And I think they're going to lose again. I think if it goes to the Supreme Court, they're going to lose again. And it actually might create precedent that's broader than that and might protect AI more than it otherwise would be. So it actually might make AI harder to regulate in the long term. So it could very well be counterproductive.
Amazing. So now I want to shift gears to the frontier AI regulation.
Yes.
Obviously, California got a lot of attention last year with the SB 1047 law, bill. It never became law. So what's in this bill? What's in bills like this? Where do you think the action is this year, if anything's going to happen?
Yeah, so SB 1047 changed quite a bit during the course, because California's session is so long. It goes from January to September. So I'll talk about
plenty of time for massive amendments.
Yeah, right. I'll talk about the final version of SB 1047. Basically, what it did was it said that if you are a frontier model developer who trains models greater than a certain cost or computing power, then you have to publish what's called a safety and security framework is what this law called it. Anthropic calls it a responsible scaling policy. OpenAI calls it the preparedness framework. Everyone has a different name for it. In the European Union, it's the code of practice. Basically, it's a document that says, on the company's behalf, here's how we evaluate major risks from our models. Again, catastrophic potential. Here's how we sort of measure for them. Here are the if-then commitments we will make regarding if we see these capabilities in our model, this is what we'll do to either mitigate them or like we're going to impose usage monitoring to make sure that these capabilities can't be accessed.
And just how much like leeway did this bill give the companies? What if I said hypothetically, we think the risk is of an AI Chernobyl and our response plan is to tweet about it?
Yeah. So, right. In principle, there are no parameters put by this law on the companies.
So interesting, right? Just tell us what you're going to do and then promise to do it.
Anthropic would be very welcome to say, our plan is to talk about it and we're not going to do anything. Dario is going to write a long blog post and they're not going to get anything else. But the laws, the SB 1047 also has provisions regarding reasonable care, this term from liability, which is basically that you have to exercise the conduct that a reasonable person in your shoes would have taken while you're making these decisions.
So if you're staring down the barrel of an AI Chernobyl disaster, maybe tweeting is not the reasonable response.
Yeah. Well, if every other company in your field has a very robust plan.
Right, because of the social determinant of reasonableness.
Yes.
Yeah, which courts care a lot about.
And it's also, it's an interesting question how courts would actually determine the reasonable person standard in the context of like super intelligence development. Like, is it an inherently unreasonable task to do this in some sense, right? Like, is it inherently kind of crazy? And thus is the reasonable person standard even really appropriate? But probably step number one on that would be saying, let's see what your peers in this frontier AI development industry are doing. So in that sense, the law would incentivize companies to like have a robust plan.
And so this reasonable care standard, you said it's tied to liability law. So I assume what this ultimately results in, the mechanism of incentivizing companies to do something more than just tweet is they could lose a lot of money in the court.
It would be the prospect of getting sued, yeah. And basically it said you have to publish this plan publicly. You have to make it available to the public. You can make a redacted version available to the California Attorney General. And we're going to have also some whistleblower protections. And
just help us understand, why would we want something like a whistleblower protection? Who thinks that's a good idea and why do they think it's a good idea?
Basically, the idea is that there might be decisions made in the course of developing an AI system that do not relate to the decision about whether to deploy that system, but instead relating to how do we, what kind of safety mechanisms or procedures are we going to take? How seriously or how are we going to think about the problem of alignment, which is sort of ensuring that the systems do what you want them to put it simply. There might be times when an employee thinks that is a disastrously bad decision, and maybe it's a year before the model is released. So it's a decision made entirely behind closed doors. Or the other thing is that if you have this responsible scaling policy, that is a document that is supposed to not just describe how the company behaves with respect to models, but really it's about like corporate process. It's kind of about like the general business practices of the Frontier AI Lab. And so if an employee observes that a company is not following their publicly stated responsible scaling policy, the whistleblower protections are effectively your only enforcement mechanism.
Right, because it's mostly voluntary, and so you don't have inspectors going into these companies and noticing. So if you don't have whistleblowers, you should expect to never detect violations.
Yeah,
right?
1047 did also have auditing provisions. So it did require that you basically create an auditing industry in the state of California that would audit frontier AI companies for compliance with their responsible scaling.
With their own voluntary taken on.
Or, well, no longer voluntary because now required by SB 1047.
Well, sorry, I should say it's required that they have something,
Yes.
but they almost get to decide what that something is.
They
So
have
it's basically-
complete discretion to decide.
It's a third-party auditing industry that only holds you to your own promises.
That's right.
Yeah.
That was basically...
So pretty tame, at least in the universe of conceivable regulations about something like this.
I would say, yeah. I mean, I think there's a very legitimate question as to whether or not it would really work.
What do you mean by would it work?
Well, so, I mean, I think that, like, negligence liability, it can, in principle, incentivize all kinds of good behavior by companies, right? The possibility that...
Cars are pretty safe.
Cars
Most
are pretty
of that
safe.
is liability.
A lot of that is liability. That's right. However, you know, me crashing in my car is not an existential threat for...
It's not a Chernobyl.
For Toyota.
Yeah.
Whereas the kinds of catastrophic risks with which SB 1047 dealt are probably existential risks for almost every company implicated. I mean, I think that, like, if someone used Llama 6 to create a bioweapon...
Probably the last llama.
Yeah, I would, and I mean, I think that would bankrupt even Meta. You know, the potential liability you could face. Certainly, OpenAI and Anthropic, which are not profitable, would be, you know, completely underwater.
Yep.
So there's a legitimate question as to how much liability incentivizes corporate managers when the liability risk is effectively an existential threat
To the company's existence, not to humanity's existence.
That's right, to the company's existence, yeah. Or to humanity. I mean, both, really, I guess.
No,
in some
I mean, but
sense.
it's really interesting that we put it in these terms, right? Because for them, sort of the maximum corporate penalty is corporate, you know, dissolution and bankruptcy. And then there's the societal penalty. And the question is the threat of corporate dissolution enough of an incentive to persuade these companies to take what are appropriate safeguards given the nature of societal risks? And not every founder, and I would go so far as to say very few founders are as crazy as Sam Bankman-Fried. But I do think Sam Bankman-Fried is sort of interesting as an example of the type of human, right, that can come out of Silicon Valley. Because he very famously said if he could flip a coin and if it's heads, everybody on Earth becomes, you know, twice as healthy, twice as rich, and has twice as long of a lifespan. And if it's tails, the Earth blows up. And he's like, yeah, I'd flip that coin.
Yeah,
and
yeah,
like,
right.
Okay, there are people out there in Silicon Valley who have a risk tolerance that is not what I would, you know, put under the shall we call it reasonable care.
And Sam Bankman-Fried, investor in Anthropic.
Yeah, original. He's no. I think his money's all gone now.
No longer,
but yes, it's true.
And actually, the FTX fund, right, is like I think going to be made whole because of the
Anthropic gains.
How well Anthropic has done, ironically. Yeah, right. I think that's true, and I also think that there's just this real question about what this would actually incentivize beyond the status quo, particularly given these companies do all publish their responsible scaling policies.
Has X published a responsible scaling policy?
They have one, and they have talked about it publicly. I don't know that I have not personally seen it, but I know that it's being written. Okay. The only company that hasn't, it would actually be Ilya Sutskever's Safe Superintelligence, ironically, has not published a safety policy.
Yeah, maybe they're waiting till they've reached some level of technical maturity and before they do it. I don't know.
Yeah, and there were other problems with SB 1047 that are like more technical, but also the things I deal with. I should say, like, my primary interest is the frontier AI policy. That's mostly what I think about.
So if you were advised, well, let me ask one question before I get to what would you do if you were king for a day kind of a question. But this state versus federal world that we're headed into, whether the states get it right, whether they get it wrong, is there anything that concerns you about the fragmented landscape? I mean, I think about, for example, when I was talking to the people in the EU who wrote the EU AI Act, a lot of them consider GDPR like the villain of the story, ironically, because here in the United States, we so often see them as birds of a feather. But they said the problem with GDPR is that all the implementation, enforcement, interpretation of the law occurred at the national level. So what you had is an EU high-level law that actually created a more fragmented market, not a less fragmented market.
Yeah.
And that's one of the problems that they were trying to solve, or at least not to repeat, in the case of the EU AI Act. And now I look at, the American system, which is a true federal system. You would expect there to be a lot more commonality. But how much of a fragmented market could we have in a world where these states do this? Or would the companies just comply with the strictest law nationwide the same way that, for example, California gas mileage standards have had nationwide implications?
What worries me much more is the possibility of states with contradictory laws. That's what starts to
Thou shalt always, thou shalt never.
Yeah, right.
Yeah.
If Texas has a no viewpoint discrimination law, and another state has an algorithmic discrimination law.
Yeah, no censorship, no hate speech.
Those are in inherent
conflict.
tension with one another, right? And I do think that's another thing about just to go back to the algorithmic discrimination laws for 1 second. One effect that it would have on the companies, the frontier AI companies, is that I believe the outputs of chatbots would be significantly more censored and significantly more sort of like they would have to be shoved into a place where they don't have possibly any risk.
And what do you think like the outcome of that is? Is it going to be like I cross state lines and my chatbot gets dumber or gets smarter, or do you think it's going to be more of like how would that be implemented if you had to guess?
Yeah, I genuinely don't know. I think it might come down to like, in the limit, I think it would be you truly do have different versions. You're accessing different model weights in different states, depending on where you are. And I think that's a terrible outcome.
Yeah.
I think that is a terrible outcome. So in an ideal world, we would have technical standards for these things that are set by the federal government. I think there are ways to achieve common technical standards, even in a world where the states plow ahead with what they want to do. I'm realistic about the fact that I don't expect federal frontier AI policy to materialize in the next 2 years.
Yeah, absent some kind of forcing function, like very large public scandal, it's hard to see how they would generate legislative momentum for anything like that.
That's right. Yeah. That's right. So I think there are ways to do this, but the states, it's very risky going with the federalist patchwork.
Yeah. So you said your primary area of focus is on these frontier AI model laws. Let's say Gavin Newsom is out there watching you on this and gives you a call and says, Dean, what should I do? I want to take another whack at this law, but I want to get it right this time. Yeah. What does right look like?
So I think I'll step back for 1 second and just go back to the SB 1047 example and say that one thing about SB 1047 was that it created this possibility of negligence liability for harms above $500 million. But it said nothing about harms below $500 million. And that is $500 million in like direct damages. The problem with that is that invites the AI companies into what I call the tort liability casino, where if you have one breach in the dam that protects you from tort liability, all of a sudden every trial lawyer in the country will run into that, and you'll be looking at class action, multi-district litigation, and you could have judgments against you in the tens of billions of dollars, even for something whose direct measurable harm was less than that. And SB 1047 was silent about more mundane kind of tort harms that could happen. And I think we might be in a world where, like today, I think AI models might commit technical torts every single day, right? A defamatory hallucination is a tort, right? There are tort cases against character AI. For there's a boy in Florida who killed himself while talking to a character AI chatbot. There are tort cases against them. Those cases have not been decided, but they also haven't been dismissed. And that should tell you a lot right there, because most software cases, tort would have been dismissed by now. So I think that like AI companies are facing this enormous, completely undefinable blob of tort liability that could truly be existential for the industry, and if not existential, could really shape it in ways that I think would be bad.
So what would you do?
So what I would do is I would create a pathway for safe harbor from tort liability. I think that's really the most important thing.
Since a lot of our folks, are more focused on military AI or other aspects of, technology policy, remind folks what a safe harbor is.
A safe harbor is basically it can be structured in somewhat different ways, but it's basically it's a defense that a company can have against a lawsuit for a tort lawsuit by somebody. So it might be that it's just your sort of like on its face, this company has safe harbor. You cannot, a suit against them is going to be dismissed.
So, okay. So like this would be, would the EU code of practice be this, right? So it's like, hey, some kind of harm was created, but our model was certified as compliant with the EU code of practice. And so therefore we cannot be sued because, we did what we were supposed to do.
It could be something like, I don't know if the EU directly has that provision, like a safe harbor like that, but it could be like that, right?
Yeah.
Where it's like somebody, either a government or a private group, publishes a set of technical standards that if you comply and are certified to comply via an audit, then you receive safe harbor from tort liability unless it can be proven in court that you either lied about your compliance or in some other way.
Or negligent in some kind of way, yeah.
If you're reckless, for example, recklessness wouldn't be covered here. So, I think that is that would be a great path forward.
So your desired end state is not that companies have to do nothing and that there's no regulation whatsoever. Your desire is that we establish what are the minimum set of things that they must do in order to get this safe harbor, and then that frees them more or less from the specter of court cases that could be ultimately, sort of backdoor to regulation.
Yeah, and I'm of the opinion that, I'm pretty bullish on deep learning capabilities, and I think we will soon see systems. Within the next 2 years, I suspect we will see systems that most people are like, yeah, if you release that without any safeguards, that would probably just be like de facto irresponsible.
Yeah, I mean, I think it's really noteworthy to me that even Mark Zuckerberg has sort of said, yeah, the bioweapons thing is real, and we should not release llama versions that make it easier for a non-evil genius, maybe like an evil moron, to develop bioweapons. And that's like the king of open source, who's very anti-AI regulation, I would say.
That's right.
Even he is out there sort of saying we need this.
So I think, and the other virtue of this program is that it is, as I imagine it, it would be effectively opt-in, where if you want the safe harbor from tort liability, you can get it. But if you prefer the status quo, and you prefer kind of going it your own way without it having to comply with technical standards and also with facing tort liability risk, well, then go right ahead.
And who's the furthest along in mapping out what would constitute a good safe harbor provision? Like, is there a bill out there that you like? Is there a draft out there that you like that sort of games this out, or is this something that you're working on?
It's something I've been thinking about at an intellectual level and kind of trying to put the blueprint forward for. There are some legislators who are thinking about this, and I think before the session is out, you might see some drafts. I'm not a political analyst, so I don't know what the political chances are. I imagine the trial lawyers will have a thing or two to say about this, but I think that there will be some frameworks put into place, or at least like presented relatively soon.
And as they get presented, I think we can trust that you're going to be writing about them on your Hyperdimensional Substack. And Dean, I learned a lot. I always learn a lot when we talk, so I just want to thank you so much for coming on the AI Policy Podcast.
Thanks for having me, Greg. It's been fun.
Great. That'll do it for us.